Mediation plays an incredibly important role in trust litigation. So a question people have about mediation, for starters, is what is the difference between mediation and arbitration? And they're very different. Arbitration is binding in general. And so that means you have someone who sits sort of as a judge. They hear your case, you present your facts, you present your evidence, and they issue a ruling. And whatever they say, you're stuck with it. That is arbitration. Mediation is not that. Mediation is where you have a mediator and really experienced attorney or a retired judge who will work with each party to try to craft a resolution that everyone agrees to resolve the litigation. So the way it normally works is the attorneys for each side will submit something called a mediation brief to the mediator in advance. Sometimes they share it with the other attorneys, sometimes they don't. And the mediator will learn the facts of the case, what each party hopes to resolve, and sort of kind of where to start with the case. Usually the mediator will not even have the parties in the same room together. Each party with their attorney will be in a separate room, and the mediator will go back and forth between the two rooms, trying to help them see, both sides see what are the strengths and weaknesses of their case and discuss what some possible resolutions might be. One thing that's great about mediation is that everything that's said in mediation is completely confidential. So you can share documents, you can say things about the case, you can reveal what you know that isn't good about your case, you can do all of those things, and whatever you say can't be repeated later in the litigation. It can't be used against you. You can't say, hey, we were at that mediation and you admitted XYZ. None of that can happen. And the purpose is we want to be able to have really candid discussions in a confidential setting so that if the case can be resolved, that it will be at that time. And so at the end of a mediation, the attorneys, sometimes the mediator helps, but the attorneys draft a settlement agreement. That settlement agreement will have all of the terms of the agreement in it. Oftentimes in trust and estates litigation, that agreement has to be approved by the court. And so one of the attorneys will file a petition and say, court, we reached this agreement privately and we want you to issue a court order saying, yes, this is approved and the estate will be distributed this way or the trust will be distributed this way, and the court signs off on it. Thing to remember about mediation, the difference between arbitration, you don't have to agree to anything in a mediation. You can walk away from a mediation. You can say, I don't agree with you. The offers were too far apart. You know, we were at $1 million and you were at 100,000. We're really far apart and we're not going to get to a solution through mediation. And you can walk away and you have your confidentiality. And aside from the time spent on it, you're no worse off. But in an arbitration, no, you have an arbitrator and they're going to issue a ruling and you are going to be stuck with that. Hey guys, it's Attorney Amy. I hope you liked that video. For more content like this, please remember to like and subscribe and hit that notification bell. I post content weekly. If there's topics or issues you think I should cover, please let me know in the comments.